Okay, before I start with outline number 2, I am looking in Barbara's outline. So before I enter my materials and finish up with my materials, I have a couple notes of things to look at that I might prefer to get directly from Barbary. The first one was class action, which happened to be in the joinder section. And this is actually about 3 pages long. So perhaps I ought to just read the whole joinder section, what Barbary feels is relevant for the examination. Joinder of parties, capacity, and individual's capacity to sue or be sued is determined by the law of her domicile. The capacity of an organization, for example, association or partnership, is determined by the law of the statute where the federal law sits, except that a partnership or unincorporated association always has capacity where a substantive federal right is asserted by or against it. Compulsory joinder, indispensable parties. In certain situations, a plaintiff must join all interested parties or face dismissal of the lawsuit. The dismissal is usually sought under Rule 12b, and the issue may be raised any time up until judgment. Citing Federal Rules of Civil Procedure 19, analysis of a compulsory joinder issue follows a 3-step analysis. Should the absentee be joined? Can the absentee be joined? If not, should the action proceed in his absence? Is the absentee indispensable? So, how do you know how to answer those questions? Part 1, should the absentee be joined? Consider if complete relief cannot be accorded among the other parties to the lawsuit without the absentee being made a party, whether the absentee has such an interest in the subject matter of the lawsuit that a decision in his absence will, as a practical matter, impair or impede his ability to protect the interest, leave any of the other parties subject to a substantial risk of incurring multiple or inconsistent obligations. That's when an absentee should be joined. Complete relief cannot be accorded. The absentee has such an interest in the subject matter that it would impair or impede his ability to protect his interests, or a substantial risk of incurring multiple or inconsistent obligations for the parties who remain joined to the action. Can the absentee be joined? Now, this question consists of whether personal jurisdiction over the absentee is proper, and subject matter jurisdiction over the action after joinder of the absentee. Is not broken, say for instance, by diversity. Does not permit supplemental jurisdiction over claims by or against parties joined under Rule 19. So joinder of a party who would destroy diversity is not possible under the compulsory joinder rules. If the court has personal jurisdiction over the absentee and his joinder will not destroy diversity of venue, he must be joined. And third, should the action proceed without the absentee? In equity and good conscience, the action should proceed among the parties before it, or it should be dismissed. In such case, the absentee would be regarded as indispensable. There's 4 considerations: the extent of the prejudice to the absentee or available parties of the judgment, the extent to which the prejudice can be reduced or avoided by means of protective provisions in the judgment, the shaping of relief or other measures, Third, the adequacy of a judgment rendered without the absentee, and whether the plaintiff will have an adequate remedy in another forum, for example, if the case is dismissed for non-joinder. So that's indispensable party joinder. Permissive joinder, parties may join as plaintiffs or be joined as defendants whenever some claim is made by each plaintiff and against each defendant relating to or arising out of the same series of occurrences or transactions, and there is a question of law, fact, or law common to all parties. The court is given wide discretion to order separate trials where joinder would be unfair to a party not sufficiently involved in all the claims. Note that the court still must have subject matter jurisdiction over the claim. Joinder of claims. The policy of the federal rules is to permit the adjudication of all claims between the parties and all claims arising out of a single transaction. A plaintiff can join any number and type of claims against a defendant. When multiple plaintiffs or multiple defendants are involved, it is essential only that at least one of the claims arise out of the transaction in which all were involved. Successive claims. Rule 18b permits a plaintiff to join two claims when success on the first is a prerequisite to the second. Such a claim for money damages and a suit to set aside a conveyance that was fraudulent because of debt asserted in the first claim. Jurisdiction. When jurisdiction is based on the diversity of citizenship between the plaintiff and defendant, the plaintiff may aggregate all claims she has against the defendant to satisfy the jurisdictional amount. When jurisdiction is based on a federal question claim and diversity jurisdiction is not available, a non-federal claim can be joined only if the court has supplemental pendant jurisdiction over it. And the court will have supplemental pendant jurisdiction over the claim if it is regarded as part of the same case or controversy as the federal claim. Class action. So there's three types. I wrote them in the margin. Declaratory - injunctive, money damages / limited fund, and common question predominates. Now, Rule 23 takes a functional approach to class action device. Named representatives will be permitted to sue on behalf of a class if the following prerequisites are met. An easy way to remember them is numerosity, commonality, typicality, adequate representation, so adequacy. But to say that in the form of a sentence, a couple sentences, the class is so numerosity, that joinder of all members is impracticable. 2, the court of law or fact are common to the class, commonality. The named parties and interests are typicality of the class, and the named representatives will ensure the fair and adequate representation of the interests of absent members of the class. And the action meets the definition of any of the following three types of class actions found in Rule 23b, and I explained them just a moment ago by name, but they are referred to differently in different places. So separate actions by class members would create a risk of inconsistent results, or as a practical matter would impair the interests of other absent members of the class, or, so that one's probably common question, I think. No, it's not. Risk of inconsistent results. The defendant has acted or refused to act on grounds applicable to the class, and injunctive or declaratory relief is appropriate for the class as a whole. Example, employment discrimination claims, citing Walmart versus Dukes, which did not actually meet the declaratory injunction type for reason that it lacked typicality and commonality. Because inherently, if you're seeking money damages and they're not the same damages for every party in the class, then how could the claims possibly be typical or common? They're going to be individual, and they come as individual actions in such a case. So back to the three types. I know now by process of elimination that last one we just referred to, injunctive and declaratory relief. Well, that's a declaratory - injunctive type. The first one, separate actions by class members, would create a risk of inconsistent results, or as a practical matter would impair the interests of other members of the class. That's the money damages limited funds example. And third, the question of fact or common law common to members of the class that predominate over individual issues in a class action is superior to the alternate methods of adjudication. That is the third type. Common question predominates. Now, secondarily, consideration in treating case as a class action. The court should determine at an early practicable time whether an action can be maintained as a class action, for example, whether to certify a class, but may determine at a later time thereafter that the action is not appropriate for one for class action treatment. In determining whether to treat a case as a class action, the court should consider inter alia the following factors: the interest of individual control, the extent and nature of litigation elsewhere on the same subject, the desirability of having the whole package in this court, and the difficulties in managing the class action. Part A, court must define class claims, issues, or defenses. The court, in certifying the class, must define the class and the class claims, issues, or defenses. Part B, appointment of class counsel. The court must appoint class counsel for every certified class and expressly mandate that the attorney must fairly and adequately represent the interests of the class. The third point to discuss under class actions is the effect of the judgment. There will also be notice, jurisdiction, court approval, and appeal before I finish talking about class actions and get into then the CAFA, where we set all this aside. The effect of judgment. All members of the class will be bound by the judgment rendered in a class action except those in a common question class action who notify the court that they do not wish to be bound by opting out. Members of Rule 23B1 and B2 classes cannot opt out, however. Note that if the substantive claim of the individual representing class is mooted, this does not render the class moot. Released from, they're talking about the Garrity case. Someone was released from prison who was named plaintiff in the class action suit. Challenging parole procedure did not moot the entire class action suit. Now, A, under effective judgment, personal jurisdiction over absent class members not required. The minimum context requirement that must be met for the assertion of personal jurisdiction need not be satisfied to bind absent members of the plaintiff class in a Rule 23B3 common question suit who chose not to opt out, Phillips Petroleum v. Schutz. This allows a state or federal court to bind persons to a class action judgment under Rule 23B3, even though they have no contact at all with the state. Now, I really don't see how this is important for the bar, so I don't know why they're going into this much detail. Notice required in common question suits. Notice to all members of the class, of the pendency of the class action is required under Rule 23 only in common question suits. so that class members can opt out. The notice must state 1, the nature of the action, 2, the definition of the class, 3, the class claims, issues, or defenses, and 4, the binding effect of the class action. Notice discretionary and other types of class action suits. I think that's sufficient. Notice of dismissal or compromise is a separate notice and must be given to class members of all types of class actions. Jurisdiction, you have diversity and federal question subparts in this section. In class actions founded on diversity, only the citizenship of the named representative of the class is taken into account to establish diversity. The Supreme Court held that the amount and controversy requirement is satisfied in a class action that invokes diversity of citizenship if any named representative's claim exceeds $75,000. The class action may proceed in federal court class even if class members' claims do not exceed $75,000. The claims by the class members that do not exceed $75,000 invoke supplemental jurisdiction. That's from Alapata, ExxonMobil Corp. Versus Alapata. Again, really relevant case for Civ Pro. Federal questions action. If the class asserts a claim arising under federal law, it can invoke federal question jurisdiction. In that sort of case, of course, the citizenship of the parties and the amount of controversy is irrelevant. Court approval. The court must approve the dismissal or settlement of the class action. The class must satisfy the requirements for certification under Rule 23A and B before a court can approve a class settlement. That comes from Amchem Products versus Windsor. Now, within this section, there's notice of dismissal or settlement, and then I think you can call for a fairness hearing, but I'm going to leave it kind of at that. Procedures for settlements of class action suits. 23E requires a settlement hearing, usually called a fairness hearing, and the judgment will bind the class and permit settlement only if the court finds the terms to be fair, reasonable, and adequate. Opt-out provision, the court may refuse to approve a settlement of a Rule 23b3 class action if members are not provided a new opportunity to opt out. Thus, members who receive notice of the pendency of the class action but decline to opt out may be permitted a second opportunity to opt out, essentially to reject the terms of the settlement and proceed on their own. Appeal of approval of settlement. A class member who objects to the approval of settlement may bring an appeal. That's from Devlin versus Scardelletti. An appeal of class action certification decision. Although the court's order granting or denying the certification of class is not final judgment in the case, a party may seek review of the decision in the Court of Appeals under 23F. So that's going to set aside everything that we need to know about typical, traditional class actions. CAFA is the Class Action Fairness Act, which relaxes federal jurisdiction requirements for some class actions in an effort to make it easier for class action plaintiffs to file in federal court and for class action defendants to remove class actions from state to federal court. Congress has concluded that some state courts had certified class actions inappropriately and that greater access to federal courts would protect defendants from such perceived abuses. A, subject matter jurisdiction under CAFA. Under the CAFA, subject matter jurisdiction is established if any class member, not just the representative, but anyone in the plaintiff class is of diverse citizenship from any defendant. The amount of controversy in the aggregate, adding all of the claims together, exceeds $5, and there are at least 100 members in the proposed class or classes. Removal under the CAFA. Additionally, I'm surprised it's $5. I wrote $5 million in my notes. Removal under CAFA. Additionally, the case falling under CAFA In a case falling under CAFA, any defendant rather than all defendants may remove the case from state to. So it overrides the defendant unanimity removal requirement. Next, even if a defendant is a citizen of the forum. All right, excluded actions. Primary defendants are states or governmental entities. There is no federal court jurisdiction under the CAFA in the primary defendant if the primary defendants are state officials or other governmental entities against whom the court may be foreclosed from ordering relief. Claims based. God. Okay. Claims based on securities laws or regarding corporate governance. There is no federal court jurisdiction under the CAFA over a class action that solely involves a claim under federal securities laws or that relates to the internal affairs of a corporation and is based on the laws of the state of incorporation. Which is why I said, oh my God, is because once we finally, I think, move through CAFA, we're talking about shareholder derivative suits, and seeing that jump off the page, I was a little concerned about thinking about them as class actions. They're not. They're different. And that's what that last bit was just about. So local considerations may defeat jurisdiction. The CAFA has some provisions designed to defeat federal jurisdiction in case class actions that are relatively local in nature. These provisions contain some unclear terms. I'm just going to read the titles. Mandatory decline of jurisdiction and discretionary decline of jurisdiction. Okay, maybe I'm not. Basically, under mandatory, it's a 4-part test. More than 2/3 of the members of the proposed plaintiff class are citizens of the state in which the action was filed. A defendant from whom significant relief is sought is a citizen of that same state, where 2/3 of the members of the proposed plaintiffs are citizens. And third, the principal injuries were incurred in that state in which the action was filed, and no similar class action has been filed within the prior 3 years. So you call these relatively local in nature. And there's a mandatory decline of jurisdiction. There's discretionary decline of jurisdiction, however, a 2-part test from CAFA jurisdictional treatment. If more than 1/3 but less than 2/3 of the proposed plaintiff class are citizens of the state in which the action was filed and the primary defendants are also citizens of that state. In that case, the court considers a variety of factors, including whether the claims involve matters of national interest, whether the claims will be governed by the law of the state in which it was filed, and whether the state has a distant nexus with the class members, the alleged harm, or the defendants. Protections of CAFA. There's a number more. There's coupon settlements, protection against loss by class members, protection against discrimination based on geographic location, and notification of federal and state officials. Shareholder derivative suits. I'm going to read this because it's got impact in another class I'll be tested on, corporations. So minority shareholder allegations. Under Rule 23.1, a minority shareholder suing on behalf of a minority shareholder suing on behalf of other minority shareholders to enforce some right of the corporation which the corporation refuses to assert must allege in a verified complaint that she was a shareholder at the time of the transaction complained of or received shares thereafter by operation of law. The action is not a collusive effort to confer jurisdiction on the court that it would otherwise lack, and she made a demand on the directors, and if required by state law, on the shareholders to, or the reason why she did not make such a demand. For this requirement, facts must be pled with particularity. So those are the same 3 requirements that you're going to get in corporations. Corporation named as defendant. If not so named, the court will align the corporation as defendant to reflect the antagonism. Jurisdictional amount and venue. The judgment runs to the corporation. Therefore, the jurisdictional amount looks to the damages allegedly suffered by the corporation. By statute, venue is proper whenever the corporation could have sued the defendants. So generally, we're talking about in the state of the incorporation. In court approval, the court must approve the dismissal or settlement in a derivative suit. We've reached impleader. We've reached intervention. Impleader again. And so this one must be interpleader. I looked at this section because I wanted definitions, and I wrote them down. So rather than read out of the outline at this point, I really only want the definition of these things. Interpleader, there's 2 kinds. Intervention. Bless you, honey. And impleader. And there's intervention. What's this? Must be there. Interpleader. Okay, interpleader, intervention. Things I was interested in. Start with interpleader. Permits stakeholder to require 2 or more claimants litigate among themselves when a valid claim may result in double liability on a single obligation. There's Rule 22 of obviously the Federal Rules of Civil Procedure, but there's also statutory interpleader, federal statutory interpleader, that is. So under Rule 22, normal rules for subject matter jurisdiction apply, including federal question and diversity. In the federal statute, it loosens the subject matter jurisdiction application, or restrictions, I should say, that Rule 22 requires. And those are lessened to the degree that the amount in controversy need only exceed $500, and there is diversity between any 2 contending claimants. So that's interpleader. Again, what is it for? It's permitting a stakeholder to require the claimants litigate among themselves. Intervention, there's another 2 kinds. There's intervention as a right, and there's permissive intervention as a right when the applicant claims an interest in property or a transaction that is the same of the action, and disposition of the action will impair their ability to protect that interest. Permissive intervention is timely with court discretion. Applicants claim or defense in main action have question of law or fact in common. No personal pecuniary interest is required, but this requires the subject matter jurisdiction grounds. Impleader is actually one, it requires common nucleus of operative fact if it's supplemental jurisdiction, but mainly it's for indemnity and contribution. Gosh, my battery is going to die. Fantastic. And so that's kind of where I'm going to leave it on the joinder. Although there's a cross claims here, co-parties may assert claims against each other that arise out of the same transaction or occurrence as the main action by filing cross claims. So I need to go into venue, and I think I'm going to actually go back to my outline because Barbie's outline is equally as long, if not longer, and more annoying to read. So mine's the lesser of two evils then in the area of venue, because the specific sections that I wanted to discuss highlighted. I might even go into my own Erie doctrine myself as well. Starting on that page. Okay. All right. So for venue, the definition is rules of venue function as a means of allocating judicial business among different courts within the same judicial system. So these rules of venue function as a means of allocating judicial business among different courts in the same judicial system. The general venue statute is section 1391. There's 3 tests: residency, transactional, and catch-all. I like that summary because I know how to speak it. So I think or I know how to test it. So how to speak it is venue is proper in 1, a judicial district in which any defendant resides, if all defendants are residents of the state in which the district is located. Clearly, if they're natural persons, it's their domicile. If they're corporations, it's where they're incorporated or headquartered, meaning principal place of business, and there's only one of those. For multi-district states, corporations are residents only in those districts where they would be subject or personal jurisdiction were the district a separate state. Personal jurisdiction analysis includes minimum contact, purposeful availment, and foreseeability, plus reasonability, which is the notions of fair play and substantial justice. And I've got the states that have multiple jurisdictions written out here. Cool. Except for California. PA has 3, New York is 4, Florida is 3, Texas is 4. Pretty sure California has at least 2. Probably more. So that was the first test. That was the residency test. Transactional test is, I guess venue would be proper where the transaction occurred. And the third test is the catch-all. Catch-all test is if, the earlier 2 parts reveal no proper venue, fallback provision applies. If there is a district where any defendant is subject to personal jurisdiction, venue for the entire action is proper there. Okay, so the transactional test, to say it from the outline, is actually venue is proper in a jurisdiction in which a substantial part of the events or omissions giving rise to the claim occurred, or a substantial part of the property that is subject to the action is situated. If I can find another highlighter. I didn't actually have that highlighted. So that's the residency test and the transaction test. And the catch-all is anywhere that they can be subject to personal jurisdiction. And the fallback provision. Forum non-convenes, right? I think, okay, yes, is Also statutory section 1404 and 1406. These statutes, probably for the most part, are all part of Title 28 of the United States Code. So for an inconvenient venue, a venue non-convenes, for the convenience of parties and witnesses, in the interest of justice, the district court may transfer any civil action to any other district or division where it might have been brought to, or to any district or division to which all parties have consented. That's 1404. In the interest of justice, where it could have been brought or where all the parties have consented. 1406 is when jurisdiction is more than just inconvenient, it's improper. The district court of a district in which a case in which is filed a case laying venue in the wrong division or district shall dismiss, or if it be in the interest of justice, transfer such a case to any district or division in which it could have been brought. Now, clearly, the choice of law is only logical, where if the venue is proper but inconvenient, you use the proper venue's laws. If the venue is improper and is transferred to a proper venue, you still use the proper venue's laws. I'm not going to read really any of the rest of this. The court has the power to transfer a case to another federal district. Convenience may consider whether the parties bargained for it or if it's foreseeable, or furthers the interest of the judicial systems. Also consider the witnesses' convenience and public interests. Standards for venue transfers. Oh God, forum non-convenes is actually a different thing entirely. It is when the forum is outside the federal system, state or foreign court. Judicially created doctrine applied by courts when it would be more convenient to hear a case in an alternate forum. It may be done sua sponte. Usually the defendant motions for it. And you can see Gilbert or Piper Aircraft for more information. I don't really know. I get the feeling that the defendant can motion for a transfer. I get the feeling that the court can too. I don't know about the plaintiff. I don't know how soon they've got to do it. I get the feeling that it has to be within a year. Unless that's just the removal of jurisdiction. Subject matter jurisdiction, that is. Now, courts sitting in diversity are obligated to apply the substantive state law that would have applied to a claim in the state where the federal court hearing the case is located. So that's where kind of there's the total crossover from forum non-convenes to Erie Doctrine, and that's like almost the definition of Erie Doctrine, if not. Generally addresses which law, state or federal, must be applied to matters in federal court. Generally, federal courts in diversity apply the substantive state law and procedural federal law. And it gives you a whole historical analysis of that, including the federal common law, which is, I want to try to get away from that. The seminal case is Erie Railroad versus Tompkins, another Pennsylvania case, 1938, when some trespasser was hit by the door of a passing freight train. And the problem that I had being tested in this section is that I can't tell what's the difference between substantive and procedural, because every time I think it's procedural, it's substantive. And then if I decide that maybe substantive is a much wider net than I thought it was, suddenly it's procedural. And I don't know where the dividing line is. And this is for NBE questions. So outcome determinative test, I want to use that sometimes, and then I feel like just recently they told me that some other test is used. Or no, yeah, actually, the most recent NBE question that I failed, I used the outcome determinative test, and really what it said was something to do with the Rules Enabling Act. And I'm just going to read what that is. The Supreme Court shall have the power to prescribe general rules of practice and procedure and rules of evidence for cases in the United States District Courts, including proceedings before magistrate judges thereof in courts of appeals. Such rules shall not abridge, enlarge, or modify any substantive right. The laws in conflict with such rules shall be no further force or effect after such rules have taken effect. Part C in this three-part citation is such rules may define when a ruling of a district court is final for the purposes of appeal under section 1291. Okay. So I'm going to read that again. But actually, before I do, here's the analysis. Question if there's a valid Federal Rule of Civil Procedure. Question if the Federal Rule of Civil Procedure is directly applicable. Question if the Federal Rule of Civil Procedure is valid by REA. FRCP may not abridge, enlarge, or modify. That's what the rules are. That's what the statute's saying. Is the FRCP valid by the Constitution? I feel like this was a question about jury selection too. Substantive right dash obligation of state citizen. And further for the analysis is if the FRCP is consistent with two aims of Erie. The two aims are to prevent forum shopping and consistent, predictable, and equitable results. So I feel like I've read everything that's actually important out of this Erie Doctrine section now. We know the two aims is to prevent forum shopping and for consistent, predictable, and equitable results. Abridge, enlarge, and modify. That's modified outcome determinative approach. Implicates the twin aims of Erie. And then there's this bird balancing. Outcome determinative test assessed against substantive policy interests furthered by the state and federal practices. State substantive policy furthered is state practice bound up with the definition of rights and obligations of the parties. Countervailing federal interest, federal rule promotes federal substantive policy interests, i.e. right to jury or due process. So I'm going to read this Rules Enabling Act one more time, just because it's so crazy. Content. 1A. The Supreme Court shall have the power to prescribe general rules of practice and procedure and rules of evidence for cases in the United States District Courts, including proceedings before magistrate judges thereof in courts of appeals. So that's the scope. A is the scope. B, it's a scope and that the district courts have the power to select procedural law. Now, B, such rules that they do use may not abridge, enlarge, and modify any substantive right. So, all laws in conflict with such rules shall be of no further force or effect after such rules have taken effect. And C, such rules may define when a ruling of a district court is final for the purposes of appeal under section 1291 of this title, which is referencing another statute I totally don't remember, but then I kind of do. And this is where that's probably why I get so confused, is because they like point to another thing that also is equally old and hard to understand. So I almost like the modified outcome determinant approach in bird balancing a little bit more. I like that I went through these this analysis. Where does this come from? What case is this from? Sibach versus Wilson, perhaps? Hannah versus Plummer. There you go. Asbury versus Center for Humanities. Shady Grove Orthopedic versus Allstate. And these are really important. And then there's this bird balancing test. So bird is clearly a case that we looked at. So I just went through class action, venue, Erie, and read the REA. So that is going to put an end cap on what I learned in fall for civil procedure. And then I'm going to pick up my outline, rather than Barbie's outline, for the spring semester. And actually, I'm going to pull out my case. What do I call these? Case list. In fact, actually, to discuss it rather than my outline. I'm not going to start with the outline. I'm going to start with a topical list from cases. So, Swerkerix versus Soremna is not currently the law on pleadings. Now, the law is short and plain statement of the claim showing the pleader is entitled to relief and a prayer for relief. That's your pleadings. Bell Atlantic versus Twombly, that's your what analysis is that? Or what does that look like? Claim is oh, okay. This is still pleadings, but the claim must be plausible, not just possible. That comes from Twombly, Bell Atlantic versus Twombly. There's a two-prong test for Ashcroft versus Iqbal, where the prong from Twombly was that the pleading and the facts suggesting liability to be affirmed is plausible. The second prong is whether the court finds the plausibility reasonable. That case, which was the plaintiff was an Arab Muslim detainee from like our War on Terror, and there were conclusory allegations. They found the complaint to be conclusory allegations and not well pled. Zelensky versus Phil Pierce. This has to do with a motion to dismiss for failure to state a claim. The Beak versus Aquaslide is leave to amend. And furthermore, it's talking about a late answer reveals identity of party at fault. So there's this equitable estoppel principle going on where the defendant party knew they weren't the right party. They might even knew who the right party was, and maybe they were a related party. And I think they, in bad faith, withheld discovery to prevent the plaintiff from being able to identify the party at fault and thus lose the statute of limitations. So FRCP 15 is your pre-trial amending pleading. I guess as long as you're not in bad faith, justice allows a leave to amend in the interest of justice. I'm kind of making that up, but I think it's also kind of true. Krupski versus Costa Crociere. This is the mistake of the defendant named to replead and relate back. So it's the same idea. I don't know if I might be getting the two cases a bit mixed up, but 15C is the area of law. And I really want to read the relate back rule because I don't have it quite memorized. Worthington versus Wilson is a police brutality case. Mistake of name of the defendant party. So the pleading, not mistake of name, party name is unknown. There's this Schiavone notice requirement kind of written here. So Schiavone is like another case on the topic. Defendant did not have if the true defendant did not have actual notice of the complaint during the statute of limitation, which defeats part 4 of the statutory analysis. And that's from the Schiavone notice requirement. But I think with Worthington versus Wilson, I mean, you brought your complaint against the police department or members thereof, and thus if one of the defendants isn't named who should be, they're probably on notice of this case and you may relate it back to the date of the complaint because they should have been on notice. Hedges versus Yonkers Racing Corp. This is applying sanctioning from Rule 11. That case was horrible to read. U.S. versus Hayward Robinson. It discusses permissive counterclaims from and defines the transaction and occurrence from 13A by 4 inquiries. I have 6 written down here, so I'm just going to read them all because they're like in red. So, close and logical relationship, same parties, same type of work, right to terminate affects both contracts, right to withhold monies on either contract as though for a single job, and threat of terminating one contract would apply to both jobs. Okay, I remember this now, kind of. And it has to do with counterclaims. So it's like a contract, to contractor, subcontractor, and those 6 factors are how they arrived at their holding. Mosley versus General Motors. This is to do with the joinder requirements. The 2-step analysis is on the next page. That step 1 for Rule 13 joinder, step 1 is there a common transaction. Step 2 is that they're common fact, only some logical relationship to be found. So thus FRCP 13 criteria met, appeal courts reverse and remand the district court's abuse of discretion. Okay, that might be the conclusion. But the analysis again is there common transaction, is there common fact, only some logical relationship need be found. Lehman versus Revolution portfolio has to do with FRCP 14, which allows the plaintiff to bring in another for some or all derivative liability. Then there's MasterCard International versus Visa, which deals with a necessary party definition from FRCP 19. I think feasibility as part of the necessary party analysis was considered in Republic of the Philippines versus Pimentel. That's got to be the most interesting case in the whole book. All of my case books. And NRDC versus US is about intervention. Only one intervener needed to represent the various interested non-parties, right? So when intervention is not of a right, but it's, what is it again? I was just reading it. Permissive intervention, you don't get to have like 12 interveners. One who can adequately represent the others is probably where the court draws the line. Hubler Chevrolet Inc. versus GMC. The Supreme Court granted class action certification. Class members' interest was individually controlling separate actions, extent and nature of litigating concerns the controversy already begun involving class, and the desirability of concentrating litigation on a particular forum. And lastly, the likely difficulties in managing the class action were considered. Walmart versus Dukes. I kind of talked about this already in this very recording. The holding is the policy cannot carry commonality if it created different pleas and claims. Analysis. Prerequisite of numerosity not met. I'm sorry, it was met. Numerosity was met. So yeah, there's lots of there were lots of plaintiff employees of Walmart that were impacted by potentially hiring, promotion, and pay that limited gender by gender, and then was limiting by gender. Let me say that. Okay, so numerosity was met, but commonality and typicality were not met because the claim class was not inconsistency, limited, fun, while injunctive. Okay, so that's not even really a very good description. One, it was not limited funds, we'll say that. But like I was saying before, seeking damages that predominate over injunctive relief. So they were seeking individual damage awards. Because questions common to the individual fail the predominant test over common questions when an individual damage awards are being brought. I mean, I like this holding the most when I read it that way. This is my interpretation of the holding in this case, but the fact is, there's two different types of class actions. Here, they were trying to get injunctive and declaratory relief. That's a lot more probable for a court to grant. But when you want money damages on top of that, and you have different claims and pleas, and individualized damage awards, you break your commonality and typicality. That's what was not met. Numerosity was met, sure. It wasn't really a limited fund, I don't think, but I mean, when you're coupling two different types, particularly the declaratory, injunctive, and money damage types is how. So this case defined types of class actions a lot more than like other resources I've been looking at. And so much so that I thought something different of what each type was than I was able to look up in other places. So that's a good thing this case is, can be used for. But anyhow, Gonzalez versus Google is subpoenaing a non-party for discovery. So we kind of cross into the discovery section. Rule 45 governs the issue of subpoenas in the federal system. Advisory shows the scope of discovery through the subpoena is the same as applicable to FRCP 35 and other discovery rules, FRCP 26. Basically, what need be known about subpoenas is they can't be overly burdensome. I'll just say that. The analysis of like, what does that mean? First of all, what does the Rule 26, I think this is probably the biggest one I care about, is grant orders to protect it from undue burden or expense in doing so, including orders conditioning the discovery on the requesting party paying cost of discovery. Here's another analysis. So there's the cost benefit analysis in Google is I just wrote op costs, financial expense, commitment of human and other resources, what is at stake in the litigation, extent of that defendants would be required to incur third-party discovery costs. Defendants have standing to quash on those grounds. Ratio cost of discovery is justifiable in relation to the amount of controversy and the parties' resources and the bad publicity, confidentiality, trust, trade secret information, or interests. And in Bulaki versus UBS, this is a little bit, I want to say, more important case than the Google case. Google was interesting, but this case, it aligns more to ESI, like electronically stored information. So Gonzalez versus Google, the government was asking for like search results, like Google's literal search index and results to queries, and like wanted like millions of them. And it would have been like absurd for Google to provide this. And Google isn't even a party to the action. It was actually, and go into the matter that involved the Child Online Privacy Act. Zubulowski is a little bit different because one of the parties is meant to produce discovery. So this isn't just like a non-party being asked to do governmental work. Like this is UBS has like, I don't know, 500 or thousands of emails because these people must just do nothing but email them each other all day, in which one party seems to believe that she was discriminated against by gender and limited opportunities, and she asked for thousands of emails, and some of them are just archived and not retrievable easily. But when she produced, I think 500 emails that she just had herself, and they showed there was some merit behind her request for like millions of dollars from being looked over for like some manager position, then the court was like, oh, okay, some of these emails actually matter to this case and might actually support this type of an award. And the analysis that they used was the extent to which the request is specifically tailored to discover, the availability of such information from other sources, the total cost of production compared to the amount in controversy, the total cost of production compared to the resources available to each party, the relative ability of each party to control the costs and its incentive to do so, the importance of the issue at stake in the litigation, and the relative benefits of the parties obtaining the information. So This one went in favor of the female. So she was able to the court devised some creative solution for her to get the discovery. Could have shifted costs between the parties since it was more of an interest to her to get it, but it was critical to her claim. So Cormac versus U.S. Is a patent case. The USPS mail sorting machine. This has to do with a fishing expedition. So you can't just. So discovery isn't going to. FRCP 26 about discovery is just not going to support a fishing expedition where you request any and everything. Hickman versus Taylor interrogatories. This is the original interrogatories case. It almost even is the first development of work in progress. This is when the tugboat sank in the Delaware River. Love that case. The holding is that the interrogatories were not discoverable as an unqualified right, but certainly the attorney's notes, thoughts, papers regarding the interrogatories is not discoverable. How many interrogatories can you do? I don't remember, but I'll figure that out. There's a limit, but you can ask the court for more. Poole X Rel Elliott versus Textron. Oh my God, what do I have written here? Discovery response requires cert because sanctioning for bad faith is within the authority of the court. So it applies Rule 37 and 26G on bad faith. Lack of diligence has disadvantages the other party. Because a lack of diligence has disadvantaged the other party in the litigation. This is a golfer alleging a tort against a golf cart manufacturer. Love it. And here, I'm just going to read these rules. In FRCP 37, the court shall require a party or deponent whose conduct necessitated the motion or the party or attorney advising such conduct on both of them to pay to the moving party the reasonable expense incurred in making the motion, including attorney's fees. Rule FRCP 26G3, if without substantial justification a certification is made in violation of the rule, the court may, upon motion or sua sponte, shall impose upon a person who made the cert, the party on whose behalf the disclosure response or objection is made. And FRCP 36, party must either lodge or object or an answer to a request, but cannot do both. Whatever. Rimkus Consulting. This one was an FRCP 37B sanction for failure to preserve discovery. Willful, culpable state of mind, spoliation. They were like, we just instituted a policy that would delete everything yesterday. That was fun. Colleton Preparatory Academy, Inc. versus Hoover Universal, Inc. Love these. Okay. I'm gonna just this like. So this one went into FRCP 55. For good cause shown, the court may set aside an entry of default. Rule applied on the Payne case was used in the analysis. Meritorious defense, party accounts with reasonable promptness, personal responsibility of the defaulting party, prejudice to the party, history of dilatory action, and availability of less severe sanctions. So in this case, there was like fire, claiming negligence under the UTPA, Uniform Trade Practices Act. Oh yeah, this was the roof. Okay. And so some party was not named and didn't learn about the complaint, but for like some smart person informed them, I think. And so they filed a motion to quash the service and set aside entry of default, which, for good cause, the court may absolutely do that. Setting aside entry of default. Here is totally fair because they didn't even have the right party. CompuServe Inc. versus Saperstein. Rule 16. The court may dismiss under a Rule 16 mechanism. I've said here. Oh my God. That case was really weird and confusing. Olson versus Alick is a Rule 16F dismissal. It was age discrimination case of this pharmacist who wanted to represent himself pro se. And he was sanctioned because he fired his counsel and was late to an appearance. And the court when he filed a relief from judgment because of the severity of the sanction, basically dismissing a case. It was just way too harsh. It was right before trial. He fires his counsel. He tries to show up on his own. He doesn't make it by 10 minutes or whatever. An hour, something else happens. The case is totally dismissed. And so he files a 60B relief from judgment, and he gets it because that was an abuse of discretion. It's not really very needy in terms of what rules I need to know. INRI Atlantic Pipe Corp. Stands for the court compelling mandatory mediation pursuant to an explicit statutory provision or local rule as case warrants with appropriate safeguards. And so FRCP 16 is mandatory mediation. So I guess the Olson versus Alick thing is the guy failed to appear. He might have also then failed to appear to mediation or something like that. ADIX versus S.H. Kress. It's a seminal case on summary judgment law. Oh, yeah, that was cool. Okay, I know. And then there's a Celotex trilogy that basically started on the shoulders of ADIX versus Kress and company. And there's a trilogy. It involves Celotex Corp versus Catret, Anderson versus Liberty Lobby Inc., and Matsushita Industrial Company versus Zenith Radio. So the rule involved is FRCP 56, genuine dispute of material fact. Movements not bearing the burden of proof need only assert the absence of a genuine issue of material fact via review of evidence adduced. And as to materiality, the substantive law will identify which facts are material. Only disputes over facts that might affect the outcome of the suit under the governing law will probably preclude an entry of summary judgment. I feel like one thing I learned from answering MBE as it relates to this section is that you must have, or the evidence that the court considers in determining if we're going to dismiss a case for having no genuine dispute of material fact is evidence like that's admissible at court. Party opposing the dismissal. So in the light most favorable to the party who doesn't want the case dismissed. That party doesn't have any evidence that will be admitted in court to prove that there is a genuine dispute of material fact. Probably not going to survive. It has to be admissible in court. That's what I've learned from the NBE. And it's something I don't have written here. So, Mashuta Zenith, that this is like saying a plausible metaphysical doubt must be shown. Degree of doubt must be shown. That's cool. Beacon Theaters versus Westover. This is the Seventh Amendment analysis. When is a civil case going to, what procedure is required for a jury trial, and when does it need to be asked for? What is the order in which a mixed, say, proceeding of legal claims and equitable claims need to be? Like, in what order does that need to be heard in the proceedings? And first of all, the party seeking the jury has to request it in a timely manner in writing. I don't know what timely means, but Constitution allows in civil claims jury for any dispute like over like $25 or something nominal, and so you just gotta ask it in writing and in a reasonable time, and then they're only going to hear legal claims. They're not going to listen to equity. So equity is a bench decision after the fact. But if you're in California, the order is reversed. Another jury case, chauffeurs, teamsters, helpers, local number versus Terry. They base some of their analysis on Ross versus Bernhard, looking at whether the historical analog, like the traditional grant of a case, actually called in common law, I believe, right to jury, was based on 3 parts, which was the pre-merger custom with reference to such questions, the remedy sought, the practical abilities and limitations of the juries. But it's been changed over time to just the remedy sought. So the historical analog was the first part of the analysis. Then there's the remedy sought, which is like if you want money damages, it's a legal action at common law. If you want equitable relief, it is not an action to which you're entitled a jury by the Constitution. And then practical abilities and limitations of jury. I love that. That is further described in Markman versus Westview as based on their interpretive skills. The interpretive skills of the jury. I mean, sometimes the judge is just better. So statutory policies that ought to be furthered by the allocation between jury and judge. Here, the legislative intent is uniformly in patent law application, and that's in the province of the court. That's how the case went. So Edmondson versus Leesville Concrete had to do with voir dire and peremptory challenges that were based on race, also not allowed to be based on gender, but that was, and this was a criminal, that's criminal. Batson was extended to civil trials. Okay, so Batson was criminal. This is not discussed in this case because this case civil law, civil procedure, right? So Edmondson was the application of the criminal development of non-discriminatory preemptive challenges in the civil law context, and it also extends to gender, although I don't think that case is one that I have written here. I don't think there's really any other protected classes, though. And Pennsylvania Railroad Company versus Chamberlain. Okay, judgment as a matter of law. That's what they examine here. Because affidavit and testimony of people at call station was not truly direct conflict of testimony upon the matter of fact, because he said that. Okay, so this brakeman was killed in negligence action. They had eyewitnesses and on one side, and then on the other side they had like somebody heard something and looked over after the fact, and by that they're saying when there is not a scintilla of evidence, the verdict in the party's favor have rested upon mere speculation and conjecture. So they, instead of having the case go forward, it was probably ruled as a judgment as a matter of law. So Reeves versus Sanderberg Plumbing is an ADA age discrimination case. It also deals with the JMOL FRCP 50, so I got that rule number right. Unitherm Food Sys versus Swift Eckrickson. What it's talking about is an appellate court may not consider the sufficiency of the evidence after a jury verdict when the pre-verdict motion for JMOL that has been denied was not renewed. So that one's a little bit weird, but I mean the procedure is strict. You do your FRCP 50A motion before verdict, before the evidence is submitted to the jury for verdict, and then you must renew it. I believe the dates are 28 days, maybe it's 21, I don't remember, because everything is messed up in my brain right now. Dadurian versus Underwriters at Lloyd's, London. This was another Rule 50, FRCP 50 case. I mean, Lloyd's London, right? They're the underwriter of this jewelry that went missing, and they're blaming the owner actually for. And they're saying against the great weight of the evidence. So the jury's verdict on a matter of credibility against the great weight of the evidence. That's the language. Great weight of the evidence. I think bought him a new trial. But this is where I'm a bit confused about the bar calling things like NOV and JMOL, and they're like, oh, stupid names, is what they keep saying. But they're not saying like, well, what is actually the old name? What is actually the new name? And how am I supposed to know if these are two separate concepts or what? Like, don't just tell me, oh, we changed the name. Tell me if the bar is ever going to use the old name. And what's the new name? What's the old name? And has any law changed? That I don't know. So I don't know if an NOV is different than a JMOL. They're acting, I think, as if it's the same thing. But I don't think it is. I think it's like you have a JMOL ahead of verdict, after verdict, or the option for a new trial. The renewal and the new trial motion are like practically on the same grounds. That's how I remember it. I'm getting here. We're almost done this case list. Case number. I mean, what I'm writing here is brought new trial. Bought new trial per appeal court reversed when 50 was or wasn't filed or was denied. I didn't even understand the procedure in this case. I understood the facts of this case, but not the procedure. I understood the fact that the great weight of the evidence was against the actual verdict. But procedurally, it's looking like it might not have worked out for the movement. And I don't have the basis for that decision. So Wisegram versus Marley Co. This is another J-Mole case. The holding is if the plaintiff knew by way of 50A that their evidence was being challenged, they should have brought their best evidence, their best case, rather than relying on contested evidence, thereby running the risk that they're not granted a new trial to try to argue again as available since Neely. So you kind of need to know the facts to understand this, is that I think some new information. Neely is precedent. They're following a caveat as listed son of deceased sues for wrongful death on account of baseboard heater product with expert witnesses that the defendant continually argues is bogus. Okay. I kind of remember this case, but I can't explain it. But the holding was that, like, they probably thought that the case was won. So they didn't put forth their best evidence or anticipate, okay. Or the other party then moved for one of these post-judgment motions and won without granted a new trial to argue again. And like this party who maybe won and now has to go back to trial again didn't put forth their best evidence, best case. Had they wouldn't be in that position. That's not something that they could argue based on this holding. So Connecticut versus Dorr, a new case, pre-judgment attachment. And notice in hearing prejudgment deprivation hearing. This court modified the Matthews versus Eldridge case analysis, and thus the analysis looks like this. Notice in hearing, prejudgment deprivation hearing. So actually, I think we're talking about, when you say prejudgment, you're talking about you can like get an injunction before actually getting a final judgment. That's what prejudgment means. So in Connecticut versus Dorr, they modified Matthews versus Eldridge, which is the main case on this, which I don't know why I just have a case brief on Matthew versus Eldridge, but the consideration of the defendant's private interest is a factor. The analysis of the risk of erroneous deprivation, probable value of safeguards, government interest in citizens' property rights, making reasonable improvements to governmental safeguards to provide greater protection, and the plaintiff's interest in the property. So all of those considerations go into, say, for instance, trying to challenge a prejudgment. deprivation here. So you've been deprived of something before judgment. That's only okay according to the due process clause if all of these things were considered. What is the defendant's private interest in the property he was deprived of? What is the risk of the deprivation being erroneous? What is the probable value of what the court would expend by improving the procedural safeguards? And what's the government's interest in citizens' property rights? So does it justify making reasonable improvements to governmental safeguards to provide greater protection of their property interests? And what are the plaintiff's interests in the property? Now, some procedural safeguards might include asking the plaintiff to for a security bond from plaintiff, and then that might limit their recovery, the defendant's recovery, if indeed the prejudgment deprivation was without merit. So I'm going to move on to Liberty Mutual Insurance Co. versus Wetzel, which is the final judgment rule being considered here. And it was a class action for CRA violations. And SCOTUS vacated the appeal court for a lack of jurisdiction to affirm the district court's declaratory judgment because there was no final order on prayers for relief that the appeal court can review on appeal. This was a Pennsylvania case. I kind of loved this case. They just refused to give relief, or they resolved by declaratory judgment, rendering nothing but an answer to the question about liability, but no relief or equitable remedy sought. So because it wasn't really a final judgment, it was not ripe for appeal. All these rules, I've listed all of these rules, but that entails the case. But all these rules are written here, so I'll read them, but that was the case, basically. It was that this class action was resolved by a declaratory judgment on their answering their question, but didn't provide any relief. And that was technically not a final judgment, not ripe on appeal. How they arrived at it, they considered like every rule under the book. So FRCP 54B, when there are multiple claims and parties, the decision is not final if it pertains to less than all of them. If no just reason for delay, a court may decide on one claim and thus become appealable as follows. Rule 56, an interlocutory summary judgment may be rendered on the liability alone, even if there is a genuine issue on the amount of damages. United States Code 1292A1, courts of appeals shall have jurisdiction of appeals from interlocutory orders or one of the district courts of the U.S. granting, continuing, modifying, refusing, or dissolving injunction, or refusing to dissolve or modify. So that's where I basically checked out of class because I didn't I couldn't wrap my head around all the laws that they just cited in that case. So there's only 5 more cases. Each and all of them have to do with re judicata and collateral estoppel. So, and mutuality. I'm going to name these cases, and then I'm going to read the rule, and then we're going to finish. Nestor versus Pratt and Whitney was about res judicata. There were 3 basic requirements for re judicata. Valid final judgment on the merits. It's the same claim. Claim in the subsequent action must be the same raised in the previous action, and the parties are identical or in privity to parties to the first action. So that one's not so bad. Taylor versus Sergel was this whole virtual representation of the same exact thing. There's 6 new circumstances by this virtual representation coming from lovely RBG, and I'm not reading them, and I don't think it's ever going to happen again. Virtual representation is maybe a non-party stepping into the position of maybe the previous party, and maybe that's what a whole big 6-part analysis of the last part of re judicata, where the parties have to be identical, or it might be defining what's privy. Semtech International versus Lockheed Martin. Dismissals will have the same preclusive effect as similar dismissals would have in the state where the issuing federal court is located. And that's important because of the definition of final judgment for the purposes of re judicata and collateral estoppel. Cromwell versus County of Sac. This is an 1876 case about collateral estoppel. It's probably the first one, where a second action on the same claims with the same parties was actually litigated and necessarily decided. Then there's Park Lane Hosiery Co. versus Shore, and that was, also collateral estoppel, but it's talking about offensive collateral estoppel, and that's kind of relatively new-ish idea. Where's my last page? This isn't my outline. This is the case list. So I'm just going to read the factors for re judicata and collateral estoppel from my outline. I love to believe that I hit all of the rules and analysis that I need just from the cases that we read in class. I probably didn't. I'm probably going to miss some that ought to be in my outline. But I might be able to just read that to myself without recording it. Where's my outline? And actually, I take that back. I have to read the California Civil Procedure, so that will probably pick up on anything that I didn't already discuss in this reading. One of the big things we have to talk about is answering complaint. I said what the complaint is. Pleading states a claim for relief and must contain a short and plain statement on the grounds for the court's jurisdiction, unless the court already has jurisdiction and the claim needs no new jurisdictional support. Short and plain statement of the claim showing that the pleader is entitled to relief, so you actually need to plead jurisdiction, and a demand for the relief sought, which is a prayer for relief. Those are the 3 parts of the complaint. Okay. I'm going to go to claim preclusion and issue preclusion from my outline. In claim preclusion, all transactionally related claims that could have been asserted but were not. That's where I started. But Barbary tells us that case 1 ended in a final judgment on the merits, not appealed, or final, right, not appealed. And then that case with the final judgment on the merits, not appealed, is among the same parties in the same positions or in one another, and they are arguing the same claim from the same transaction and occurrence. Now, issue preclusion, which is collateral estoppel, case 1 ended in a valid final judgment on the merits. The issues must be identical. The issues must be essential to the judgment in case 1, actually raised and litigated, where the parties had an opportunity to raise the issue or failed to do so, and the issues were necessarily decided the outcome of the case. And then the next inquiry is that issue preclusion is being asserted to a party in case 1, mutual, non-mutual, if brought as non-mutual, defensive, and non-mutual offensive. If defensive and the other defendant party is given an opportunity to fully argue the issue. If non-mutual offensive, don't have to relitigate, only if fair, which is too incentive to defend and different results. So mainly it's like a 3-part analysis with res judicata, and it's a 5-part analysis and issue preclusion. Both start with there being a valid final judgment on the merits. In res judicata, it has to be the same claim, same transaction, same occurrence, same parties, same positions. But in issue preclusion, it's about the issue. The issue must be identical, essential to the judgment in the first case, actually raised and litigated, necessarily decided the outcome of the case, and that issue is being asserted to at least one party in the case, in the first case. There's another party bringing the same issue, more likely than not. What do I have written here? Okay, so I've marked my outline in several spots. I think I might just read the page markers. The 7th Amendment, right to a jury trial. In suits at common law where the value of controversy shall exceed $20, the right of the trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the U.S. than according to the rules of common law. Blah. Okay, when do you have to ask for it? Effect. Courts favor jury trial for fact-finding when there is a hybrid case, legal and equitable, legal first, and then the equitable issues are decided by the bench, and issues can be analogized. Okay, so this has to do with the historical analog. Then I don't remember the rest of the analysis. Second analysis is like what relief is being sought, and then the third analysis is like the jury's I just don't remember the words. I see something else I wanted to read, which was the Relate Back Amendment 15C. The claim standard amendment is transactionally related to the matter set forth in the pleadings to be amended. The party standards that the amendment pleading against a new defendant involves the same conduct, transaction, or occurrence set forth in the original complaint. The new defendant received notice of the lawsuit such that it would not be prejudiced by being named, and the new defendant knew or should have known that it would have been sued but for the plaintiff's mistake about its identity. If all that's met, you can relate back to the first complaint so as not to lose. Statute of limitations. All right, so the next thing I've got, the next marker in my outline. Oh, look, there's more jury stuff. Jury selection process. Disqualification by cause. Are they able to be impartial? If not, there's a cause to eliminate them. If there's no cause, without cause, it's called a peremptory challenge. 3 peremptory challenges per side, per voir dire, and you're exercising them not on the basis of race or gender. If they are, though, however, then I'm just going by memory here because I don't really see the exact process, but I recall you've got to have the one of the party that didn't exercise the peremptory challenge has to question it, and then the party who did raise the peremptory challenge has to give their grounds on a non-discriminatory basis for eliminating juror, and I think the court has to ultimately, as long as any reason is given, that should be enough, but you have to be able to give a reason that's not based on their race or gender. There's a jury has a right under FRCP 38. A jury request after 14 days of the last pleading directed to the issue and may be granted if any reason for delay and no prejudice created. It is determined a jury is appropriate, and then jury must be selected. So that's your jury is a right 14 days after all of the last pleadings. That's the timing of the jury. FRCP 48 is telling you that the federal civil jury must be composed of 6, and it cannot have greater than 12. And I think the MBE was telling me that they have to rule unanimously. Talk about the trial phases. I don't know why I marked that. This one's legal and equity test. There's a jury role, isn't what I meant to say. Okay, so I keep going over this. I'm like obsessed with this. Okay. Legal equity jury role is all that matters now. All right, so is that my only marker? Okay, next marker is about judgment as a matter of law. In general, if a party has been fully heard on an issue during the jury trial and the court finds that a reasonable jury would not have legally sufficient evidentiary basis to find for the party on that issue, the court may resolve the issue against the party. That's what happened in that crazy one I couldn't explain, which is why you have to bring your best evidence. And grant a motion for JMOL against the party on a claim or defense that under the controlling law can be maintained or defeated only with a favorable finding on the issue. A motion for JMOL may be made at any time before the case is submitted to the jury. The motion must specify the judgment sought and the law and facts that entitle a move into the judgment. And that's your 50A. 50B is the renewal of this. How soon is the renewal gotta be submitted? That's my question. Renewing the motion after trial. If the court does not grant a motion for JMOL made under 50A, the court is considered to have submitted an action to the jury subject to the court's later deciding the legal question raised on the motion no later than 28 days after the entry of judgment, or if the motion addresses a jury issue not decided by the verdict, no later than 28 days after the jury was discharged, the movement may file a renewed motion for JMOL and may include the alter or joint request for a new trial under Rule 59. That's your motion for new trial. So it can be combined with a motion for a new trial, notwithstanding the verdict. That's what that stands for. Hopefully, if I'm right, I don't remember. I'm gonna leave it. Wait, no, I'm not gonna leave it at that. Ruling on renewed motion, the court may allow a judgment on the verdict if the jury reached a verdict, order a new trial, or direct the entry of JMOL. So they got 3 things they can do when they receive your renewed JMOL. And before I go into the next topic, I'm going to say that the FRCP 59 is new trial, and the court has the authority to throw out a jury verdict or order a new trial. In general, grounds for a new trial, the court may, on motion, grant a new trial on all or some of the issues and to any party as follows. After a jury trial for any reason for which such new trial has heretofore been granted in an action at law in federal court, or after a non-jury trial for any reason for which a hearing has heretofore been granted in a suit in equity in federal court. And the issues is how to interpret the different from setting aside a judgment as a JMOL. There's your Dorian case. Your standard is two different standards. The great weight of evidence. Courts weigh evidence on credibility of witnesses. Legal sufficiency or facts are not sufficiently clear that law requires a different result. So Rule 59, when the jury has reached a seriously erroneous result, the verdict being against the great weight of the evidence, damages are excessive, or the trial being unfair to the moving party in some fashion, proceeding being influenced by prejudice or bias. That is a, complete thought. Before moving into what is a harmless error. Example, it does not create substantial harm to a party, i.e. prejudice did not sway the jury. What's this? Okay, before I go into FRCP 61, I'm just going to read about verdicts, kind of. Mainly just giving the rule number, because general verdicts versus special verdicts. So I believe one of them is FRCP 48. The special verdicts is FRCP 49. You can have a special verdict, a general verdict with written questions, and if there's inconsistent answers, meaning they're inconsistent with the verdict, but the answers are consistent with one another, but one is the court may approve for entering under Rule 58 an appropriate judgment according to the answers received, direct the jury to further consider its answers and verdict, or notwithstanding the verdict, and order a new trial. The court allows the court to make verdict consistent with the answers. So answers are inconsistent with one another, but not the verdict. Try to argue again as available, since that was an option the plaintiff here has. Forget that. Relief from judgment per 60B. Interlocutory appeal. That's your 28 United States, Title 28 United States Code 1292 that I didn't want to talk about before, because I knew that right here I'd have an actual statement of law. The appeal court examines. This is an appellate review of new trial rulings. So you've motioned for a new trial. And you were granted it, or you weren't granted it, and you appeal that. You were denied your new trial, for example. And the appeal court examines the district court decision for abuse of discretion, which is a highly deferential standard of review, i.e. definite or firm confliction that the district court made a clear error of judgment or exceeded the bounds of permissible choice in the circumstances. Another example, record must contain no evidence in support of the verdict, or district court made a mistake of law, or standard review will never prevail on a motion jury's verdict if against the great weight of evidence, because it involves fact-finding, which is an analysis that the trial court took part in, and so they're going to defer. That's why you'll never prevail on it, because they're going to defer to the trial court who denied your new case, because they sat there during the first case and they don't think that you need a new case. Relief from judgment per Rule 60B. I just wrote after 28 days, extraordinary circumstances, miscarriage of justice. So relief from judgment or order. So you're late in motioning for a new trial under 59. Or you're not even entitled to do that. But you may still motion for relief from judgment per Rule 60 if the grounds for relief from the final judgment order proceeding on motion just terms, the court may relieve a party or its legal representative from a final judgment order proceeding for the following reasons: mistake, inadvertence, surprise, or excusable neglect, new evidence, fraud, the judgment is void, the judgment has been satisfied, or any other reason that justifies the judge's failure to recuse himself. The timing and effect of the motion, it's after 28 days. I think it's within a year is safe to say, but it's extremely rare. There's got to be, like, these grounds have got to be extraordinary circumstances, and that are raised to a gross miscarriage of the justice. So you got like a lying witness or something, or new evidentiary issues. It may be filed together with the FRCP 59, and a court can approve or deny them both at the same time. New trial. The court can also sua sponte grant a new trial. All right. Lovely. What is this FRCP 61 substantive rights? Unless justice requires otherwise, no error in admitting or excluding evidence as grounds for granting a new trial, setting aside a verdict, vacating, motioning, or disturbing a judgment or order at every stage of the proceeding. The court must disregard all errors and defects that do not affect the party's substantial rights. Rheumatoid and editor. And hey, here's this prejudgment stuff. Oh my god, it's Rule 64. That's all probably need be known. Rule 65 is injunctions and restraining order procedure. Requirements: success on the merits, irreparable harm, balance of equities, and public interest. We know that from remedy. Appellate review, final judgment rule, harmless error, preclusion doctrines. Okay, we went into that already. There's a huge deviation from that in California. Talked about it in an earlier recording. I can't believe I'm still talking. Oh, there's a million more tabs here. Rule 64, seizing a person and property. This is the prejudgment I was talking about. Remedies available under this rule include following, however designated, and regardless of whether state procedure requires an independent action. That's arrest, attachment, garnishment, replevin, sequestration, and other corresponding equivalent remedies. Encumbrance of property. Liz pendens, notice filed and recorded with respect to real property that warrants all persons of litigation interest taken subsequent to notice will be subject to the outcome. That's great. That's just great. I'm not going into that. Remember, Matthews versus Eldridge was the original analysis. I enunciated the modified analysis balancing test for due process for seizure, which was defendant's private interest, risk of erroneous deprivation, probable value of the safeguards that could be developed, government's interest in protecting its citizens' rights with more safeguards, and the plaintiff's interest in the property. Rule 65, restraining orders, I read them. The 4 requirements. Do you have them memorized, though? You absolutely do. So it has to be inadequate remedy, irreparable harm, inadequate remedy, all of that, right? Oh, likelihood of success on the merits. And a demonstration of the balance of hardships. for between the parties and then the interest of the public. So I forgot about the likelihood of success on the merits. Your temporary restraining order, your preliminary injunction, and I just read those in 4 factors. Enforcing judgments, Rule 69. Mainly, you can't enforce a judgment until, like a money judgment, until 30 days after final judgment. Appellate review. Oh, it's probably because of the appellate review. Oh my God. Standards of review. FRCP 54B. When there are multiple claims and parties, the decision is not final if it pertains to less than all of them, and if no just reason to delay, a court may decide on one claim and thus become appealable as follows. Rule 56, an interlocutory summary judgment may be rendered on liability alone, even if there is a genuine issue on the amount of damages. In USC 1292, courts of appeals shall have jurisdiction of appeals from interlocutory orders from the district courts of the U.S. granting, continuing, modifying, refusing, and dissolving injunction, or refusing to dissolve or modify. So we go back to injunctions and interlocutory orders. Kind of makes sense now that I finally freaking took remedies. The opinion controlling question of law deserving immediate appeal is an issue question of law, squishy, and the appeal could materially advance the litigation. That's an interlocutory order. There's an issue, a question of law. They could, there's some inconsistency in how that law's been applied by various districts, and the appeal could materially advance the litigation. So you wait, you appeal, and then you wait till the appeal court hears on that issue, and then you take back to the district court and let them use that appeal decision in making a decision of the law on the facts. Case. Collateral order doctrine. Rule 4 of the Federal Rules of Appeal procedure. There's 10 days to appeal interlocutory decision, stalled 30 days by 50A and 59 motion, and excusable neglect with showing a good cause, such as forum non-convenes. 3 conditions for COD, collateral order doctrine. Conclusively determinative, resolve important issues separate from merits threshold, and be effectively unreviewed on appeal after final judgment. Believe it or not, even though that is so confusing, I actually get tested on it in these NBEs. There's so many freaking notes here. Why? Okay, I'm skipping those 2. I can skip. Can I skip claim preclusion? Yeah, because that's re judicata. And what's this? Yeah, and that's a okay. I already talked about that. So review. So this is the last thing I'm going to talk about is reviewability and standards of review after FRCP 54, final judgment rule in 60, rule 60, relief. Apparently I talk about all of that in this short section. I never once talked about contempt, and I'm not going to. All right. So there's 3 standards of review. Let's just go into them first. De novo, no deference to trial court decision. The appeal court considers a new question of law or fact. I don't know when to use that standard as opposed to the clear error standard, which a judge made a fact determination and is not a close question, clearly wrong, or plain error affecting substantial rights is the difference between clear and plain. And then abuse of discretion, most deferential district court decision will stand if some rational basis and legal, proper legal standard used in the opinion. I don't know when to apply which standard of review, so I might look it up somewhere else because I didn't understand it at the time of class, and I don't understand now. And I'm done. That's all I can do. We're going to actually read next these California civil procedure laws and code, or whatever they call it. And it's 100 pages, and I've never read the 100-page outline before. But often when Barbary covers California's iteration of the federal or common law, they will set forth why it's different than the federal law or the federal rules of civil procedure here, hopefully, and set straight some of the things that I touched on or didn't get to touch on, and clarify as well as elaborate on how California purchases matters.